watch what they're doing.
Thank you. Our guest today is James Q. Wilson, presently at Boston College, and formerly, for 26 years, professor of government in the Harvard Department of Government. He was born in Southern California, went to the University of Redlands, where he was a national debate champion. I'm going to give you the full thing. All right. Yeah. His books are many, and each one of them opens some new avenue for political science. His first called Negro Politics in 1960. That's how long ago that was published. And, then City Politics, which he did with Edward Banfield. The American Democrat, which was on the McGovern Democrats, I guess before they reached that high status. There again, ahead of the game. He wrote a book on police, varieties of police behavior, books on bureaucracy and political organizations, 2 books on crime, thinking about crime and human nature, he did with Richard Herrnstein. And he's more recently moved into matters of morals and character, book on character, moral sense, moral judgment, the marriage problem, understanding America, and the best-selling textbook in American politics. And to top it all off, a book called Watching Fishes, which he did with his wife, Roberta. She did. Which she did with her husband, Jim. Right. He's won many, well, let's say the 3 highest awards I think that he could have won. He got an honorary doctorate from Harvard. He got the Lifetime Achievement Award of the American Political Science Association, and he got a Presidential Medal of Freedom. He was been on the White House Task Force on Crime, another task force on violent crime, the Foreign Intelligence Advising Board, and the Council on Bioethics. It is said that he was offered the head of the FBI. We don't know whether that's so that's an established rumor.
You're helping.
So and he was he had his ways when he was a young man, but ever since then he's been on the wrong side of corrupt politics, and nonetheless has gained recognition from a profession which is totally dominated by those who are on the other side, the right side. And so, and that is in a way I'd say the overall the most interesting and even astonishing achievement of this wonderful life. So, Jim Wilson.
Thank you very much. I'd like to conduct this as a seminar and offer what I regard as tentative views on the following question. By what rules can we practically manage the problem that terrorists create for the United States? I say they're tentative views because my mind is not clearly settled on what could work, least of all what would work. My views are also tentative because, as you can tell from Harvey's wonderful introduction, it's proved difficult for me to settle my mind on any particular subject for a long period of time. I keep flitting from one to the other. Just about the time my critics gang up on me for having said the wrong thing in Book A, I'm halfway through Book C. The fundamental question one must answer when deciding what to do about terrorists is whether one will rely on civilian law enforcement. Civilian law enforcement is well suited for arresting and prosecuting and convicting bank robbers. Is it well suited for arresting, convicting, and imprisoning terrorists? President George Bush, for most of his administration, rejected the law enforcement approach when he was replaced by President Obama in the White House. The president then said he would reject the military approach and embrace a law enforcement approach. But then in practice, although not in theory, since he did not officially announce he had changed his mind, he began to adopt much of President Bush's strategy. Anyone who has followed his changing views on who should be in Guantanamo and the extraordinary extent to which he has used drones to attack and kill terrorists overseas is evidence of how his practice has been modified. The problem of law enforcement is that it is difficult to manage terrorists when you think the first goal is to decide whether or not they have been convicted of a crime. Dealing with terrorism means dealing with people who are attempting to inflict harm in a premeditated fashion on a large number of innocent civilians for the purpose, or so it would seem, for the purpose of creating fear or panic or public disruption. We have had experience with terrorists in this country. It goes back many decades. During the Civil War, President Lincoln suspended the right of habeas corpus as soon as shots were fired in South Carolina beginning the war. It was, to me, a controversial but a necessary decision. It was controversial because the Constitution does not specify who can suspend the right of the writ to habeas corpus. But it was necessary because there was simply no way for Congress to act speedily on this matter, and the president had to take steps to deal with people who were attacking the country. The effort to manage the writ of habeas corpus was more or less settled by a case in which the military arrested one Lambden Milligan, an American citizen who had planned to use terrorist tactics to disrupt northern facilities in Indiana. And in the case of Ex parte Milligan, the court said that Mr. Milligan could not be arrested and convicted by a military commission as he was, could not be sentenced to death by a military commission as he was, because the civilian courts in Indiana were operating well, and as long as the civilian court was operating and the person was an American citizen, then the citizen had the right to access the civilian courts. After the war was over, the threat of the Ku Klux Klan arose, and in 1871 approximately, Congress passed what later became known as the Ku Klux Klan Act, which empowered, among other people, President Ulysses S. Grant to suspend the right of habeas corpus in 9 South Carolina counties for the purpose of combating the Ku Klux Klan. So those were the experiences that defined our involvement with terrorism during the Civil War. The second period involved the Second World War, when a Nazi submarine deposited 4 saboteurs on Long Island and another 4 in Florida. They were caught by an alert American military person on Long Island, and they more or less turned themselves in Florida. They were arrested, tried by a military commission, all sentenced to death, even though one of the persons sentenced to death was an American citizen, having been born here. In a Supreme Court case, ex parte Quirin, the Supreme Court decided that this strategy was justified and raised no argument against it. The third episode in dealing with alleged terrorists was during the Second World War. Later on, when people of Japanese descent, especially those living in California, were required to live in relocation camps far from their home. I believe this was a profoundly wrong decision. Some of you may disagree, as the Supreme Court did disagree in the Korematsu case in 1944. But no Japanese American was ever convicted of espionage or sabotage. And later on, when Ronald Reagan was president, the country, in his words, apologized for this decision and paid Japanese Americans over $1 billion in reparations. At the time this was happening, some Germans and some Italians were also sent to relocation camps, but their numbers were a small fraction of the over 100,000 Japanese that were sent to these camps, and only a small fraction of the number of persons born in Germany and born in Italy who were living in this country. The fourth time that we've had to confront terrorism was, of course, in the aftermath of the bombings of September 11, 2001. At this point, our legal arguments have changed because by this time, the Supreme Court had become quite energetic in overseeing the process of dealing with terrorists. And it raised, and to its satisfaction disposed of, three issues that arose at the time. The first issue was, should a person who is arrested as a suspected terrorist be entitled to a habeas corpus writ? That is to say, a writ which a judge could issue requiring that the person being detained be produced before the judge so the judge could determine whether or not the person was lawfully detained. Secondly, should such persons be given a Miranda warning? You all know what the Miranda warning is, unless none of you have ever watched television. And the Miranda warning entitles a person to refuse to answer questions and entitles a suspect to access to an attorney free if necessary in order before the person's statements can be used at a trial. And the third issue is, under what circumstances is it necessary that the trial of a suspected terrorist occur before a civilian court as opposed to a military commission? So let me talk first about the habeas corpus issue. Abraham Lincoln suspended that right for Confederate soldiers. Ulysses S. Grant, as I've already said, suspended it for members of the Ku Klux Klan, at least in some southern counties. Franklin Roosevelt did not even consider the possibility of habeas corpus where the Japanese Americans were relocated, nor did he consider it for the 400,000 plus Axis soldiers who were detained in American prison camps located in this country. None got a habeas corpus writ. All stayed in prison until the war was over, when then, of course, they were repatriated to Germany or Italy. After the war ended, the Geneva Convention was signed in 1949. We hear a lot of references to the Geneva Convention, especially on mystery stories, as if everybody knew what it says. And in fact, it's a rather complicated document. And it does not define a terrorist. But in its language, it implies that a terrorist is a person who meets some or all of the following criteria. They are fighters. They wear no distinctive dress or insignia. They are not commanded in the field by a superior officer. They do not carry their arms openly, but carry them clandestinely. And they, in the words of the Geneva Convention, do not fight in accordance with the laws and customs of war. Now, the convention doesn't specify what the customs of war are, but apparently in 1949 everybody thought they knew. Al-Qaeda and other terrorist organizations do not meet these conditions. And this view that is implied by the Geneva Convention suggests that the convention does not apply to them. And when George W. Bush was president, he issued a statement saying that these people would be described as unlawful combatants, and that was the policy that he followed. But the Supreme Court had a different view. Ex parte Quirin, the case involving the Nazi saboteurs in 1940, allowed them to be condemned to death by a military tribunal. 10 years after... Pardon?
Don't you have the wrong date there, Professor Wilson?
What,
Is it 1940?
Yeah.
We were at war with the Nazis
No,
until
1941.
41.
It's probably my making a mistake. Thanks for being alert to that. You'll find many more mistakes, so don't doze off. You'll have a lot of work to do. 10 years later, this decision was reinforced. The ex parte Quirin decision was reinforced by a Supreme Court decision called Johnson versus Eisentrager. It seems that some German nationals in China had attacked American military dispositions then in China. The American armed forces arrested these people, tried them before a military commission, and then imprisoned them in Germany in a prison operated by the American military. The 6-justice majority in Johnson v. Eisentrager upheld all of this, said these people were properly tried, properly convicted, properly imprisoned, and held in defense of his opinion that we could not extend constitutional guarantees to these Germans because it would require us to overlook 6 facts. First, they were enemy aliens. Secondly, they had never resided in this country. Third, they were captured abroad. Fourth, they were tried by a military commission. Fifth, they were convicted of offenses committed outside this country. Sixth, they were imprisoned outside this country. The court went on to say that if we thought we should extend to these German prisoners all of the rights that American citizens have, then not only would they be entitled to the writ of habeas corpus, but also to the protections of free speech and free press, and they would not be deprived of life, liberty, or property without due process of law. There were 3 dissenting justices. One wonders what the court would have said if they had become a majority. Would they have held that before shooting Germans in the battlefields of Europe, should American soldiers get a warrant? This is my feeble effort at humor. I don't think they would have said that, but it is clearly implied. That decision, Johnson versus Eisentrager, lasted for 24 years until the Supreme Court began to confront the kinds of terrorists that emerged in the Middle East. The case involved 2 Australians and 12 Kuwaitis who were captured in the Middle East by American forces and then sent to the American prison at Guantanamo Bay, Cuba. This time the court decided by a vote of 6-3 that these people did indeed have the right to a writ of habeas corpus and were entitled to ask for that writ from an American civilian district court. To justify its decision, the Supreme Court said that these 14 men, 2 Australians and 12 Kuwaitis, were nationals of countries, quote, not at war with the United States, and were being held in a prison in a place over which this country had exclusive jurisdiction. Well, when the German prisoners were arrested leading up to Johnson versus Eisentrager, we were at peace to Germany. The war had ended. Peace treaty had been signed. And secondly, they were held in an American prison over which American authorities had exclusive jurisdiction. The court, in reaching its decision, said it was not overruling Johnson v. Eisentrager, but in fact, in my opinion, it was. It said that terrorists could not be locked up if they were residents of friendly nations. But such an argument overlooks the nature of terrorism or being unlawful combatants. By definition, a terrorist belongs to a terrorist movement, not to a nation state. By definition, a terrorist acts on the terrorist's own initiative and does not wait for a nation state to act on his or her behalf. America does indeed run Guantanamo Bay, but it also ran the prison in Germany where the Nazi soldiers were held. And it was not clear in reading this decision, in which the majority of liberal judges was reinforced by the opinions of Sandra Day O'Connor and Anthony Kennedy, exactly how the 2 cases differed. But that decision, Rasul v. Bush, changed by fundamentally the law by which we deal with terrorists. Bush administration fought back by obtaining from Congress the passage of the Military Commission Law of 2006. And this law allowed military tribunals to try alien enemy combatants. And it also passed the Detainee Treatment Act that denied to people confined at Guantanamo Bay the right to have a habeas corpus hearing. Those 2 laws lasted 2 years. In 2008, the Supreme Court said they were in large measure unconstitutional. In particular, the ban on habeas corpus proceedings was unconstitutional. In justifying its decision, it went on to repeat many of the arguments in Rasul v. Bush and added some others. It said, now I'm not making this up, this is what they said, The residents of certain territories, such as Hawaii, after America acquired that territory, were at the moment America acquired the territory entitled to the writ of habeas corpus, even though they were not American citizens. But in order to balance the ticket, the court went on to say that the writ of habeas corpus would not be available to people who were residents of lands ceded to the United States as a result of the Spanish-American War, countries such as the Philippines. By this argument, the court seemed to imply that terrorists had more rights than Filipinos. This will come as news to Filipinos, but happily they don't spend their time studying American Supreme Court decisions. And what the court did not say, if this is the distinction it made, that you have to give the writ to the terrorists in Guantanamo Bay, why we also should not have given the writ to the 400,000 Axis prisoners held in prisons, camps in this country during the Second World War. So we have, with respect to the writ of habeas corpus, a kind of confused record, leaving the matter today unsettled. The second issue is the Miranda warning. The warning, obviously, that you need not speak unless you wish to, and you're entitled to a lawyer, if necessary, at government expense. That law establishing the Miranda warning has, since 1966, been modified in some important ways. Let me just mention some of the modifications. The court has held that if a person is asked whether they wish to speak or not, or whether they wish to have a lawyer or not, and the person remains silent, does not answer the question, then police questioning can continue, and his voluntarily made statements, if any, can be used against that person in a trial. If the police would inevitably have found incriminating evidence, such as a body killed by the suspect, then the failure to supply an attorney would not bar a conviction because the crucial evidence would have been found inevitably. In this case, the Supreme Court was dealing with a person who killed somebody, would not reveal where the body was. The police mounted a search, found the body, found evidence that he had killed the person, and that evidence was admitted even though the person had not agreed to comply with the Miranda warning. The most interesting exception to the Miranda warning, however, is the public safety exception. 1984, a case arose when a police officer arrested a man suspected of rape and found that in a warehouse where he was hiding, he had an empty gun holster on him. The officer asked him, without giving him a Miranda warning, where his gun was. The man pointed to a pile of empty cartons at the back of the warehouse and said, "The gun is over there." The officer found the gun, came back and gave the man his Miranda warnings. The suspect waived those rights and admitted that he owned the gun. But after he was convicted, he appealed his conviction on the grounds that the gun was found without him having been warned and therefore should have been excluded from evidence. The Supreme Court rejected this appeal and held that, quote, "a concern for public safety must be paramount to adherence to the literal language of the prophylactic rules enunciated in Miranda," close quote. Now, is this public safety exception, finding a gun that belongs in a man's empty holster a few minutes after he is arrested, is this adequate to protect law enforcement personnel questioning terrorists who are trying to learn intelligence about who might be working with them and whether other plots might be underway? Now we come up to how the federal government has responded to all these developments. In October 2010, the FBI issued a new directive to its special agents saying that they are entitled to ask any and all questions that are reasonably prompted by immediate concern for the safety of the public or the arresting agents without advising the arrestee of his Miranda rights. That is legally sustainable if by the use of other evidence, forensic evidence, material evidence, and the like, you convict the man in court. I don't think it's adequate if you use the statement the person makes without having been given the Miranda warning as justification for convicting them in court. Then in exceptional cases, the FBI memorandum went on to say, the FBI agents would seek the approval of their special agent in charge in their home office for, quote, continued unwarranted interrogation, close quote, in order to, quote, collect valuable and timely intelligence, close quote. That ruling by the FBI has not been tested before the courts, but inevitably it will. Well, why was it written? It was written because the FBI took a lot of criticism over the 10 months after the famous underwear bomber was arrested in the Detroit airport. You will recall that this person, Umar Farouk Abdul Muttalib, had tried to make a bomb taped to his underwear go off on this plane as it approached the Detroit airport. One passenger came up to him and said, "Your underwear is on fire." And when they realized, because the man didn't respond very promptly to this warning, that something amiss was on foot, he grabbed him and other passengers grabbed him and they detained him until the FBI could be called after the plane landed. When the FBI arrested him, they questioned him for 50 minutes without giving him the Miranda warning, and then he was given the warning and he was supplied with a lawyer who advised him, of course, to say nothing. Happily, members of his family later persuaded him to talk, and we did learn some things from him about the terrorist plot of which he was a part. At about the same time, the FBI also questioned Faisal Shahzad, an American citizen who confessed to being the Times Square bomber. He was carrying a bomb hoping to blow up hundreds of people in Times Square. Again, we were lucky. He was given the Miranda warning, but said enough to give us valuable intelligence. But in both cases, the underwear bomber and the Times Square bomber, things could easily have gone the other way. Neither might have talked. We might have learned nothing. The intelligence we got and the FBI acted on might never have been available. So the FBI directive is a step in the right direction, but it is only a step. Now, to go back to where I started, I regard terrorism as a military attack on this country and its people. It is no different from an attack by a battalion of tanks or a battalion battery of artillery or bombers being flown from a hostile country. The only difference is that terrorists act without a return address. You don't know for sure where they came from or what other people in league with them might intend to do. They are not, in short, bank robbers. But the Supreme Court has in effect said they should be treated as bank robbers. And if you wonder why, ask Justice Anthony Kennedy, who after the retirement of Sandra Day O'Connor became the fifth vote in 5-4 decisions that have approved the Supreme Court insisting that terrorists be treated as if they were bank robbers. Now, proposals have emerged in Congress to deal with this problem. Senators Joe Lieberman and Susan Collins have introduced a bill which, if it were passed, and it has not been voted on yet, would require top American intelligence officials to be consulted after a suspected terrorist was arrested or detained in the United States. Specifically, the law would instruct the Attorney General, who has been told of this arrest, to consult with the Director of National Intelligence, the Director of the National Counterterrorism Center, the Secretary of Homeland Security, and the Secretary of Defense to find out whether this person was a terrorist. As I read those statements, it immediately will occur to you what several problems are. First of all, it is limited to foreign terrorists at a time when homegrown terrorists are becoming much more common. Homegrown terrorists are the most rapidly increasing component of the FBI's view of terrorism. So limiting this bill to foreign terrorists neglects a large problem with homegrown terrorists whose loyalty to overseas creeds, leadership, movements is just as strong. Secondly, the procedure they suggest is, to put it mildly, cumbersome. If I were the Attorney General and told I had to interrogate those 4 senior officials, most of whom were cabinet officers, before I could do anything, I would resign, saying they won't even return my phone calls, assuming they're in the country at the time I place them. Thirdly, if these 4 people he must consult disagree, only one person by the law can settle a disagreement, and that is the President of the United States, who might or may not be in his office at the time the Attorney General calls. So I want to suggest a different approach, and this is the part where my views become tentative and where I particularly would value your suggestions. My suggestion occurs in 2 parts. The first part is that we pass once again the Military Commission Act, but this time not leave it focused on unlawful enemy combatants, as if the Geneva Convention defined for us who we're looking for. And second, rather, we should define it as applying to terrorists, whether homegrown or foreign in origin. And it should allow these people to be tried by military commissions, and it should deny them the right to a Miranda warning or the writ of habeas corpus, except by procedures confined to those military commissions. The military commissions can easily provide these, but limit the appeals by which they can be tested to the Court of Military Appeals, or possibly beyond that, the Federal Circuit of the Court of Appeals. I would prefer leaving it with the Court of Military Appeals in order to shorten the problem of identifying whether these people are entitled to this writ. Secondly, I would define a terrorist. My proposal would narrow the application of the law to persons who meet one or both of 2 definitions. First, they are members of groups, or they have been personally trained by a terrorist organization. Those organizations, and we could list them, would be Al-Qaeda, Hamas, Hezbollah, Islamic Jihad, Shining Path, and any other groups. The State Department has a list of terrorist organizations, and it's not difficult to apply it. Or alternatively, they are clandestine agents who are attempting to commit premeditated violence against non-combatant targets for the purpose of creating panic. If there is a disagreement involving the military commission, or if a person appeals to the Court of Military Appeals about the definition of a terrorist, then I would favor allowing a 3-judge panel, akin to the panel that now authorizes NSA warrants under the Foreign Intelligence Surveillance Act, to decide the matter. Now, the Supreme Court, in all likelihood, failing the replacement of Justice Anthony Kennedy, would probably overturn my proposal. In which case I would vote, were I in Congress, to convert this into a constitutional amendment. And if we could get 2/3 of the votes of Congress and send it out to get the votes of 3/4 of the states, then this would become a constitutional provision which would override Supreme Court views. In the debate about this constitutional amendment in Congress or in state legislatures, critics of it, and of course there will be many, should be asked to explain why several presidents, including not only George Bush and Barack Obama, but others, including Bill Clinton, have authorized the murder of Osama bin Laden by Navy SEALs, have authorized the killing of Ataya al-Rahman and Anwar al-Awlaki by drones launching bombs at them. Anwar al-Awlaki was born in this country and is in fact an American citizen, even though he is now living in Yemen. This would be a spirited debate. I wish I could get in Congress to participate in one side of it, but I think that that's unlikely. Those are my remarks, and what I would like to hear from you are not only your questions, but your suggestions, because I'm still thinking this through. Thank you very much.
questions. You said, early in your talk, you said that Obama had changed his views about Guantanamo.
He changed his practices, yeah.
Oh, practices. How would those practices change?
Well, he has ceased pressing Congress for acquiring money to relocate the Guantanamo Bay inmates to a prison inside the United States. That was his proposal.
That
When he
doesn't change
discovered, pardon?
But surely you don't think that's a change of his view. That's just a change.
I said it was a change of his practice. I didn't say it was a change of his view. I meant to be clear that his views are something. I have not heard them stated. His practice, however, has been changed when he discovered first that most of the inmates of Guantanamo Bay will not be accepted by any country overseas. Some have been sent overseas, and they've rejoined their terrorist fighters. And secondly, imprisoning them in a special prison in the United States has been voted down by Congress, and therefore there is no way to empty out Guantanamo Bay, at least at the present time. So the practice has changed.
Well, the interpretation that I believe is simply that he can't do what he wants to do. He's simply submitting to the political reality. But my other question, though I think I am still like you thinking out my overall position on these issues too. But though I think I'm closer in my viewpoint to you than to the ACLU. What I usually hear, I think, in heated arguments from people to my left, if memory serves me correctly, is that in the history of the last 10 years, large numbers of alleged terrorists have been tried and convicted in civilian rather than military courts, and very few have been tried and convicted in military courts. Am I right in thinking that that's the history, and are those to my left correct in thinking that this is a good argument for the effectiveness of civilian courts in dealing with this problem?
I do not know the numbers. My sense is that apart from a handful of terrorists, such as Padilla, who were convicted in a civilian court, and a significantly larger number who were convicted by military commissions, that the view that you have heard is not correct. But I cannot give you the numbers, so I cannot swear that I'm right, but that is my sense, that more people have been convicted by military commissions than by civilian courts. And the president, again, has changed his practice when he and the Attorney General said many of the leading inmates of Guantanamo Bay would be tried by civilian courts in Manhattan. I wrote an op-ed piece for some newspaper in which I explained what this would mean. It would mean securing the jurors from prosecution. It would mean bringing in an army of personnel to guard it. It would mean closing down 1.5 square miles of lower Manhattan, where one finds the courts, the police headquarters, and a couple of very expensive apartment buildings, in order to protect the environment during a trial that would surely last a long time. I think that, I'm not saying my views made any difference, but many other people made these views, and I think that the practice has changed, that in effect, the Obama administration, or perhaps the Attorney General, Mr. Holder, has abandoned the idea of trying people in civilian courts because the reaction against it has been so strong. And now this could change. And it leaves open the question, and this is a question I thought you were going to get to and probably would if I stopped interrupting you. How long do they stay in Guantanamo? I mean, we know when we released the Axis prisoners, it was at the end of the Second World War. We sent them back to Germany and Italy.
The non-terrorists, 400,000.
That's right. But when do we release the people in Guantanamo Bay? If terrorism is a permanent feature of our lives, we'd be holding them forever until they die. Is that the right thing to do? Given what those have done, I would say I would be willing to accept it, but some people might worry that keeping that facility there for that long would be a mistake. Eventually, by the way, our access to Guantanamo Bay will expire. We have it on a lease. We don't have it in perpetuity.
Thank you very much for your talk. I don't have any policy recommendations, but I have a kind of general question which I would classify as a moral question. I was always interested, especially in high school, with the Nuremberg Trials and the legal proceedings against the Nazis, the death squad cases too. And I even went to the trouble of reading all the transcripts, which was scarring for me. But I was very shocked to learn later on that Churchill's official opinion on the Nuremberg trials was that they were a bad idea. His recommendation was just to interrogate high-ranking Nazi officials, for intelligence value, and then to shoot them. Not even to have a trial, and not even to have a public execution.
That is correct. Churchill did
And
that.
my first impression when learning of his opinion was that he was a sort of hard-headed and practical man, and it was a somewhat of an amoral view. That may be true. It seems to me there's another possibility, which is that he viewed the Nuremberg trials and that sort of thing as immoral or obscene in a certain way. I don't know quite how one would characterize them as obscene. I mean, one speaks of a victor's court. Another way to speak of it would just be that there's a certain kind of insanity in trying to be so strictly legalistic in dealing with such basic situations of sort of friends and enemies as well.
Yeah.
And I throw it to you just as general question that on the one hand I'm very sympathetic and care a lot about individuals like yourself getting the policies right, the legal policies. On the other hand, I can't help but feel a certain kind of tug that if this is a war or some kind of ongoing struggle against people who, for whatever reason, want to kill us, there could be some kind of moral problem with attempting to find formal legal solutions to the challenge. There could be some kind of issue. And I don't know how to express that way. But I wanted to throw it out to you because it seems to me that America's obsession with legal habeas corpus cases from the Civil War, for example, which are still studied in this department for reasons I don't really understand fully, that's caused by a moral concern, not by a logistical or legalistic concern. So just sort of throw that out to you, and the moral significance of this kind of legalistic thinking, whether you think there may be a limit to how scrupulous we can be without being kind of obscene.
Well, lots of Nazis were executed without the benefit of a trial. The man who ran Auschwitz was taken back to Auschwitz and hanged from a pole built in the center of the Auschwitz compound. And there was no trial because everybody knew he'd been the leader of it, and the only resentment anyone expressed was that hanging was too good for him. So
This was a United States government action?
No.
Who did it?
The Polish
The military forces, and I'm not sure, probably the Polish army, but I'm not positive about that, yes. You correctly described Churchill's view. My view is different. I would defend the Nuremberg trials for the same reason that some of the prosecutors defended it. This was an effort not to satisfy our desire to be overly legalistic. This was an effort to use the trial to explain to people just what happened and to make it clear that the people who were arrested, many of whom were then executed, had done things that were horrible and had done it knowingly and had planned it. And I think the argument in favor of the Nuremberg trials from that perspective was justified. I think only one missed out on execution. That was Albert Speer, who was their architect and designer and who didn't build Auschwitz and didn't invade any countries with his own efforts. In this, the real moral question is the following. We have killed an estimated 600 people overseas by bombs dropped from drones run by the CIA. 600, and that's not a trivial number. Yet when we capture them, we tie ourselves in knots trying to decide what kind of procedures we should use and what kinds of penalties they should be exposed to. How do we maintain both strategies? The answer to that question is not easy. I think dropping bombs from drones means we're practicing a war by unconventional means. Having a trial means we stop thinking that way and revert to our traditions of managing ordered liberty by having set procedures and formal arrangements. Is there a course of action that is somehow in between those views? And that's what I'm struggling to find, and I'm not sure I found it, but that I think is the key issue. Sydney.
It's an analogy that was running through my mind that I'm not sure is a good one, but let me try it, having to do with the First Amendment.
Mm-hmm.
We all know that the famous line, you're not allowed to yell fire in a crowded theater.
You're not allowed falsely to.
Falsely to it, that's right, absolutely. And therefore, that is an exemption for the First Amendment protection. And that's right.
Mm-hmm.
But then the next question is, suppose you look at the process by which you want to keep people out of a theater who might yell fire falsely, and therefore you have people waiting outside deciding who looks dangerous as they come in, which would be decided on what they're wearing, what color their skin is, maybe what language they speak, and so forth and so on. So there's a two-stage process, and it's the other stage, the stage of figuring out who's a likely suspect, that can be a dangerous one if we are not very careful. It's clear that in Guantanamo, there are various people who got stuck there, that if you read what I read in the newspapers, they didn't really deserve to be stuck there, but once they were stuck there, they were stuck. And the question is, in relation to terrorism, how does one control for the possible biases of all sorts of things that could come up under one administration or the other, looking for left-wingers or right-wing Ku Klux Klan people or militant leftists, and doing something to them that makes them likely to be thought to be terrorists, and therefore brings them under the system that you're talking about. And that's where sometimes the concern for singling out terrorists and treating them in a special way makes one nervous if one doesn't really always trust the government. And I'm told that you're not always supposed to trust the government, so I'm asking you.
Well, in keeping people from going into a theater and falsely shouting fire, it seems to me you would add to the list of traits you already mentioned whether they have a PhD. I've gone to enough faculty meetings to say that this puts a lot of people at serious risk. I'm surprised that you think that there are people in Guantanamo Bay who shouldn't be there. There have been several military commission trials. Some people have been released. My view is that you maintain the tradition of military commission trials, but you deny the shortcuts, such as Miranda warnings and writs of habeas corpus, simply allow a hearing in which the inmate is represented by an attorney cleared to hear classified information. It's an important consideration because you don't want the trial to be an avenue for revealing what we know or what we think we know about terrorism generally. I have no problem with that. So that, the Supreme Court doesn't seem to feel that the military commission could operate without approximating the characteristics of a civilian court, and that's where I draw the line. I think maybe it's because I was the defense counsel on my ship's military court. By the way, everybody I represented got off, just to make sure you understand. I threw myself into this. That military commissions, in my understanding, Uniform Code of Military Justice, works pretty well. Makes mistakes. Every system makes mistakes, but I think military commission is a good way to go. And the Supreme Court, it seems to me, should say hands off, unless somebody can find an example where their rights have been, important rights have been clearly violated. They were convicted when in fact they were innocent, or their appeal process was shut off. But, and do you really think there are a lot of people at Guantanamo Bay that wound up there by accident?
There certainly are cases that you read about in newspapers.
Which newspaper? The New York Times, the Boston Globe?
Yeah.
Well, you see, there's the problem. You see, you and I read different
Read
newspapers.
different newspapers.
That's
right. Another example, and I'm not prepared to push this case, but there have been things in the newspaper about one of the so-called militant or Muslim organizations in Gaza, who has been on the State Department list of a terrorist organization for a long, long time. And a number of people, Israelis and so forth, have said, this is a mistake, that it's gotten on the list and we can't get it off the list. And that they don't really understand this organization and they're making things worse by keeping these people, by making them terrorists, by calling them terrorists.
Well, what you should do is read an interesting book entitled Bureaucracy that explains what's going to happen. Be sure to pay the full retail price. Yes, sir.
I wanted to go back to this point about Miranda and terrorist speaking, and I wanted to ask your reaction to me finding this idea that somehow the Miranda rights are instrumental in whether or not a terrorist speaks. I find that problematic, and maybe it's an empirical reality that you read a terrorist their Miranda rights and they stop speaking, but it just seems somewhat behaviorally odd, I guess is the best terminology for it, because we would think terrorists as some sort of military actor would have made a decision about what's valuable to them in terms of intelligence and things like that, and if they're being questioned by the FBI, they've already made a decision about whether or not they're going to speak or they're not going to speak. And then the idea that a lawyer comes in and reads them their rights, and they say, "Oh, never mind, those are my rights. I guess I better stop speaking." It seems like that would be an odd behavioral reality. So I guess my question is too. I mean, do we actually know that's what's happened in these cases? And if it is, I mean, how would we explain something?
We don't know how many people who have been arrested and with or without Miranda rights have gone ahead and spoken. Several have. The underwear bomber did. The Times Square bomber did. But there are dozens more about which I know nothing. But that raises a different question. If Miranda warnings are not very important to people who are committed to a terrorist cause, why does the Supreme Court get bent around that axle? And simply terminate the procedure if the Miranda warning has not been given. I don't understand it. Mickey?
Yeah, Jim, I have a question about your at least semi-reliance on the possibility of a constitutional amendment clarifying such things. It seemed to me that when one looks over the range of constitutional amendments, including the one that didn't work and had to be retracted, the more specifically oriented the amendment is, the more it leans toward substance rather than process, the more difficulties arise. Now, are you fully comfortable with both the strategic utility of an amendment and the likelihood of any such thing passing? Or is it some devious Wilsonian technique to extract action from the Congress by other means?
All Wilson techniques are devious. You should learn that by now. I do not plan, should we come to the constitutional amendment stage, to introduce some lengthy document about how you define terrorists or like. It would be a procedural document. It would say, in dealing with people who have been defined as terrorists, the following procedures shall be used. And the next point would say, in trying to decide who has been a part of a terrorist group, this would be a policy that would be settled upon by agencies X, Y, and Z, in the executive branch with a suitable appeal to the judicial branch. But I wouldn't say what any of these are. Let them work it out. I would try to focus on procedure. Am I optimistic? Well, that's certainly not. On the other hand, I would love to be part of the debate in which they explained to me why we could drop a bomb on Anwar al-Awlaki, an American citizen, but can't try somebody else in Guantanamo without the full panoply of personal rights.
A follow-up. Let me make it more precise. Do you really think that defining terrorism is a fit subject matter for a constitutional amendment?
Sure.
And alternatively, would you believe that defining war is a fit subject for a constitutional amendment?
I'm not trying to write a constitutional amendment that would define terrorism. I'm trying to say that terrorists should be treated in a manner that is different from criminals, and that just as the First Amendment does not define speech, does not define press, the 14th Amendment does not define due process. These are all matters that the court would struggle with on the basis of a serious effort by people in the executive and legislative branches to come forth with definitions that people could accept. The key of the amendment would be to tell the courts, stop trying to convert the management of terrorists to the same system we use to decide whether you're a bank robber. These are two different subjects. We're not going to define how they differ. We're going to allow the government to propose its strategy. I think that modest rap on the knuckles would be useful, because right now there's no indication that they're aware that there is a fundamental difference. Ruth?
As I see it, one is trying to protect the country in two ways.
Mm-hmm.
One, protect it physically from terrorism,
Mm-hmm.
and the other is to protect the confidence that we have in a system of justice. So just before coming here today, I read this terrifying, to me terrifying, bit of news that the families of the people who were killed by terrorists in the Sbarro restaurant attack in Jerusalem
Mm-hmm.
are about to be released.
Mm-hmm.
And what the government of Israel has so kindly done is to inform the families that the people who have killed their relatives are about to be set free
Mm-hmm.
into the world
Mhm.
and so forth. So isn't the question really one of effective, of the death penalty?
Mm-hmm.
That, in other words, unless one is prepared to use the death penalty in cases of judgment, one almost has to resort to drones. In other words, to get the people killed by some means. If you do not have a system of justice or a citizenry or whatever it is with backbone enough to actually make sure that people do not return to the activities to which they are committed, and to some extent to protect people who want to believe in justice, who want to trust the countries in which they live.
Well, the federal government in this country does have the access to the death penalty,
Yeah.
as well as a dozen or so states. And
Do you think it would apply?
it would apply in some cases, certainly. I mean, I can well imagine a military commission trying somebody at Guantanamo Bay, saying your acts were so reprehensible that you will be executed. And subject to a non-reversal by an appeals court, that would be the rule that would stand. Israel, as I recall, does not now have the death penalty. It had one briefly when Adolf Eichmann was in its possession.
Well, it has it for treason.
It has it for treason. I didn't think what Mr. Eichmann did was treason. I thought it was monstrous, but not treasonous. I can't help you with the Israeli problem. We have a death penalty in this country, and my guess is that in the pulling and hauling between the legislative branch and the courts, it would be applied over time to persons who were convicted of terrorism, and Congress would pass statutes to say, this is what it looks like. You can't put that in the Constitution. The Constitution is silent on the subject of the death penalty. All we outlaw are cruel and unusual punishments. And that largely means pulling people's fingernails out and that sort of thing.
But do you think it would be applied at this time?
What do you think it would be, which?
Applied by either a military or a civilian?
Oh, yes, certainly. Oh, financial commitment, no doubt. Sir?
I just want to make sure that I'm clear about, broadly speaking, the procedure of the military commissions as opposed to the civilian courts. And so there would be adversarial representation, but by military officers of the defendants. And there'd be different rules of evidence, I suppose, right? That's sort of the important difference between civilian courts and military commission, as well as the sort of strategic or pragmatic arguments you mentioned concerning the securing of Manhattan, etc. So that's how we prefer the military commission. Although you don't want to be precise about the exact procedure, you're basically inviting Congress to rewrite their laws, etc. Right? So good. I wanted to see if I was clear on that. So the second part of the question is, what we expect from this, from these military commissions, and it seems to me that the upside is, as you say, to create this median position or to revisit it between drone strikes and long, very expensive process in civilian courts, and. So we're avoiding political theater, I think, right? In other words, we're just trying to get an effectual solution to the problem of how to deal with these people. I don't know if there are requirements that the process is speedy, but it seems to me that if we're looking at a situation where the war on terror could go on for an interminable length of time, that for the sake of legitimacy, it's important to get it over with, basically. Whether
Get it? What is it?
Get the trials over
Oh,
with,
yes, right.
right? In other words, it seems delegitimizing to have these people, hanging sort of over our heads. So even if the result is their imprisonment or execution, that it's quick seems to me to be very important. So that would be, again, another part of the procedure that we sort of have to insist upon. Would you agree with that?
Military commissions act with greater speed than civilian courts, yes. And we could establish, if we wanted to make a list of the things they could and could not do, but on the whole, they would act faster. And the appeals would be less complicated. The average length of time in this country between imposing the death penalty on a state prisoner and that person's execution, the average time is 12 years. In California, it's 35. In Connecticut, it's 22. Now,
so this is an argument, if I can interrupt, for a sort of truncated appeal process, keeping within the military commission system.
That's right, and an appeal process that does not get recycled. One of the reasons for the long period of time is that there will be an appeal all the way up to the state courts. The state courts will act, then it comes back down. Then there will be an appeal all the way up to the federal courts, and the federal court does it. Then the nature of the appeal will change. So up through the state courts and up through the federal courts on different ground. A skillful lawyer can make this process last indefinitely. That doesn't happen in military commissions. There is an appeal, but it is reasonably brisk. Andy.
I'd like to ask a question about what's between the drone attacks on the one hand and Miranda warnings on the other, which has to do with enhanced interrogation. You've given careful circumspection to these cases, and I wondered if you had thoughts about whether enhanced interrogation has been effective in terms of getting information that's helped us defend ourselves in the war on terror.
Explain what you mean by enhanced interrogation.
What I mean is in certain publications, probably like those Professor Verbo was pointing to, there has been an argument made that certain kinds of interrogation that have been described variously as harsh, including the use of waterboarding, have simply not been effective, and that's always struck me as a difficult thing to know about without having done the research, and I'm wondering if you have considered this question and what your thoughts about it are.
I've considered it as much as I can from the non-classified materials that are available. And you find considerable discrepancy. One source I consulted said there have been 3 examples of waterboarding, and they were all successful. Khalid Sheikh Mohammed being one of them, who talked about a lot of things because he didn't like water flowing down his throat. At one time, waterboarding was used in the SEER program, that is to say the Survival, Escape, Rescue, and Evasion program that all special forces go through. Today, I can't find a clear account of whether they still use it on Americans. They may have changed, they may not. It's surrounded in secrecy. The one issue where I thought there would be clarification is when there was an argument between former Vice President Cheney and Attorney General Holder about the meaning of enhanced interrogation, and Cheney said, the government possesses memos that describe its results. The Attorney General should release them. Attorney General, I don't think, released them. So the answer to these questions is out there somewhere, but I don't want to guess as to what the answer is. I am prepared to believe that waterboarding, for example, is the sort of thing that facing a dire emergency, somebody has planted a bomb in Cambridge in one of the holes that the street maintenance crews have so thoughtfully dug all over the city. Even worse, outside the Harvard Faculty Club, and we need to know where it is, and we would do almost anything to find out where it is. It's not hard to generate a theoretical support for enhanced interrogation, but you just don't know how many cases it applies to. And this argument between the Vice President and the Attorney General about memos that describe its results is a very interesting one. And the next time I see one or the other, I'm going to ask them if an unclassified person such as myself can see them.
Thank you.
Yes.
Let me raise the flag of civil liberties. One of the concerns that I always have is the person being falsely accused, being falsely classified. And you're proposing a definition of terrorism, which might go into the Constitution, but then you need people to determine whether or not someone who's being accused is a terrorist. And presumably, what you are proposing are fewer safeguards for the for which the falsely classified or falsely accused would be able to escape this process, which they find themselves having been assigned to. What mechanisms do you see? And this, by the way, I think is probably behind some of the Supreme Court decisions, is to eliminate the necessity to make these definitions as to who is a terrorist, who isn't. Most of the examples you have given are pretty easy, but you always have, you go back and take a look at the cases in World War I, some of the communists or others who were defined and prosecuted under the law. What protections do you envision with respect to such individuals that might be falsely accused?
Well, if they're falsely accused and held in an American facility, such as Guantanamo Bay or whatever replaces Guantanamo Bay, they would have access to a military commission where their attorney would, as his first issue, try to raise the point that they are not terrorists and challenge the prosecutor to establish that they are. And I think that there are substantial advantages to doing it this way than doing it in a civilian court in the glare of publicity with all of the extraordinary safekeeping and peacekeeping measures that you have to use to surround it. So I would like an independent, neutral tribunal to settle this question. I don't want to say we're just going to decide administratively what's a terrorist organization. The Supreme Court managed the First World War problems of falsely accusing people of being subversive fairly well. It decided that the First Amendment applies to the states and governs the Attorney General, and developed a body of case law as to what is or is not an acceptable form of speech. I think that law is reasonably good. One can quarrel about it, but I think it's reasonably good. But answering the question of whether somebody is a terrorist or not is more complicated, because in this free speech cases, what you know is what they said, how the police reacted to what they said, and you have to decide who's right. In the case of the terrorist issue, they denied they were a terrorist, and we have to turn to X, somebody, to explain what a terrorist is. That's the part of the puzzle that has not been adequately solved. My view is that the government should be told by Congress it has to provide a definition of it, and that in applying that definition, the person to whom it is applied has to have the right to appeal a decision that he is a member of that group. So I'm in favor of a neutral court making this decision. I just want it to be a military court, not a civilian court.
What about, here's a question. I was thinking, as things stand right now, we have an incentive to kill people or shoot people with drones or shoot people rather than capture them. And it would seem perhaps that the most effective deterrent to shooting someone would be the possibility of capturing him and gaining information from him through interrogation techniques, which might be called enhanced or might just be called torture. And so what about that? What about the what would you do about the drone attacks? Continue.
I don't understand the difference between a drone attack and having somebody lined up over the sights of your rifle is one and one only. In a drone attack, there's likely to be collateral damage. Shooting the person over the sights of your rifle minimizes the chance of collateral damage. The reason why one supports drone attacks is that often you cannot make an arrest. These people are surrounded by protectors and friends and family. There's no way to get American troops in there. I mean, getting Navy SEAL Group 6 into Pakistan to kill Osama bin Laden took absolutely heroic efforts. And even then they lost their helicopter. You can't afford to do that very, very often. So I'm willing to accept the risk of drone attacks on the understanding that if the collateral damage becomes large enough for people to notice, that we will modify the rules under which drone attacks are carried out.
Just to follow up quickly, it seems that, back to that Churchill point, that if enhanced interrogation techniques are not normally available now, there's a much larger possibility that the Army will just decide to kill people rather than arrest them. For example, bin Laden could have been taken alive, it seems to me.
Might have been.
He was.
He was killed, and they had instructions to shoot him there.
Mm-hmm.
And they probably might have lost one or two SEALs, but they probably could have tried to take him alive.
Mm-hmm.
I don't know if they would have succeeded, of course, but they didn't.
Mm-hmm.
And there's many reasons for that, including all the Nuremberg Trials stuff that you raised. But it seems that in general, you have a strange situation. Maybe I feel like I'm piling on Dr. Mansfield's point, in which very strict legal guidelines are going to lead to the CIA and the Army killing people rather than arresting them in many circumstances. I wonder if you have what you think of that. I don't know if it's intended or unintended consequences of legalism there.
As an ex and not very important military veteran, I don't think that's the way the military reacts to these matters. After all, the military doesn't run the drone attacks, it's run by the CIA. And I don't think the military says to itself, well, we let the drones kill them, we'll do something else. That's just not the way the culture of the military is formulated. It's formulated around doing your job with your buddies and achieving goals that are set for you by your captain or your colonel.
How about the CIA receiving instructions from the president?
Well, that's a different matter. I wish I knew more about that. It's a very interesting question, but we don't know. I'm going to end pretty soon because my throat is slowly giving out, but I don't want to cut you off. Go ahead.
You talked in your talk about the idea of finding some middle ground between military commissions and the traditional civilian courts. So I naturally wondered if the United States is not the only country to wrestle with issues of handling terrorism. Have you any knowledge of some other country that has found some kind of middle way between those two possibilities that you are searching for?
Well, I've spent a lot of time looking at the British police system. It doesn't issue Miranda warnings. It doesn't have well, it certainly has a writ of habeas corpus, but it doesn't issue Miranda warnings. And it can hold a person at arrest without bringing them before a magistrate. Last time I counted for close to a month, whereas in this country, if you don't bring them before a magistrate within 48 hours, you're already in trouble.
They have a different interpretation of habeas corpus.
Well, yeah, they know they have to produce the person before a magistrate, but they have a lot more time to do whatever they want to do before they make this production. I can't speak about other countries. My guess is if you're inclined to commit a terrorist act, you really don't want to do it in France or Germany. My advice would be to stay.
Come right.
Come right here.
Well, with that bit of advice, we thank you all.